Loving versus Virginia was a landmark civil rights decision of the U.S. Supreme Court, in which the court ruled that laws banning interracial marriage violate the equal protection and due process clauses of the 14th Amendment to the U.S. Constitution. The ruling, in this case, overturned the ruling in Pace v. Alabama. The facts of the case. 1958, two residents of Virginia, Mildred Jeter, a Negro woman, and Richard Loving, a white man, were married in the District of Columbia pursuant to its laws. Shortly after their marriage, the Lovings returned to Virginia and established their marital abode in Caroline County. In October 1958, of the Circuit Court of Caroline County, a grand jury issued an indictment charging the Lovings with violating Virginia's ban on interracial marriages. In 1959, the Lovings pleaded guilty to the charge and were sentenced to 1 year in jail. However, the trial judge suspended the sentence for a period of 25 years on the condition that the Lovings leave the state and not return to Virginia together for 25 years. He stated in opinion that
Almighty God created the races white, black, yellow, Malay, and red, and he placed them on separate continents. And, but for the interference with his arrangement, there would be no cause for such marriage. The fact that he separated the races shows that he did not intend for the races to mix.
After their convictions, the Lovings took up residence in the District of Columbia. In 1963, they filed a motion in the state trial court to vacate the judgment and set aside the sentence, on the ground that the statutes which they had violated were repugnant to the 14th Amendment. The motion not having been decided by October 1964, the Lovings instituted a class action in the United States District Court for the Eastern District of Virginia, requesting that a three-judge court be convened to declare the Virginia anti-miscegenation statutes unconstitutional and to enjoin state officials from enforcing their convictions. In 1965, the state trial judge denied the motion to vacate the sentences, and the Lovings perfected an appeal to the Supreme Court of Appeals of Virginia. Thereafter, the three-judge district court continued the case to allow the Lovings to present their constitutional claims to the highest state court. The Supreme Court of Appeals upheld the constitutionality of the anti-miscegenation statutes and, after modifying the sentence, affirmed the convictions. Thus, the appeal of the Lovings before the highest court of the United States of America. The Lovings did not attend the oral arguments in Washington, but one of their lawyers, Bernard S. Cohen, conveyed the personal message he had been given by Richard Loving.
Mr. Cohen, tell the court I love my wife, and it is just unfair that I can't live with her in Virginia.
The issue is whether or not a statutory scheme adopted by the state of Virginia to prevent marriages between persons solely on the basis of racial classifications violates the equal protection and due process clauses of the 14th Amendment. The ruling of the U.S. Supreme Court finds the miscegenation law of the state of Virginia unconstitutional, as this statute deprives the Lovings of liberty without due process of law, in violation of the Due Process Clause of the 14th Amendment, and the said law does not serve a valid legislative purpose. The ruling of the Supreme Court of the State of Virginia upholding the constitutionality of its miscegenation law is reversed by the U.S. Supreme Court based on the following arguments. First, marriage is one of the basic civil rights of man, fundamental to our very existence and survival. To deny this fundamental freedom on so unsupportable a basis as the racial classifications embodied in these statutes, classifications so directly subversive of the principle of equality at the heart of the 14th Amendment, is surely to deprive all the state's citizens of liberty without due process of law. The 14th Amendment requires that the freedom of choice to marry not be restricted by invidious racial discriminations. Thus, under the Constitution, the freedom to marry, or not marry, a person of another race resides with the individual, and cannot be infringed by the state. Second, the Equal Protection Clause requires the consideration of whether the classifications drawn by any statute constitute an arbitrary and invidious discrimination. The clear and central purpose of the 14th Amendment was to eliminate all official state sources of invidious racial discrimination in the states. At the very least, the Equal Protection Clause demands that racial classifications, especially suspect in criminal statutes, be subjected to the most rigid scrutiny, and, if they are ever to be upheld, they must be shown to be necessary to the accomplishment of some permissible state objective, independent of the racial discrimination which it was the object of the 14th Amendment to eliminate. Indeed, 2 members of the court stated that they cannot conceive of a valid legislative purpose, which makes the color of a person's skin the test of whether his conduct is a criminal offense. Lastly, there is patently no legitimate overriding purpose, independent of invidious racial discrimination, which justifies this classification. The fact that Virginia prohibits only interracial marriages involving white persons demonstrates that the racial classifications must stand on their own justification as measures designed to maintain white supremacy. Thank you for watching.